Professor Wang, thank you very much for the nice introductory words. Dear students, ladies and gentlemen, I'm very pleased to be here. I'm trying to speak slowly, but I assume that most of you are familiar with English. If there are any problems, I understand that Professor MeiHsin Wang would do some translation. So when thinking about this lecture and what I think what might be of interest to you, I thought I'd give you a little bit of update on the European patent system and the attempts of the European Union to unify Europe. As you know, in Europe we are a sort of a bunch of nations. So you see here a map of Europe with lots of different countries. And some of these countries, shown here in red, are members to the so-called European Patent Convention. So, if you want to apply for a European patent, you do that by way of the European Patent Convention at the European Patent Office, which is located in Munich, the city where I come from, which is right here. And the European Patent Office then examines your European patent application and grants a patent.
Professor Markus 呢，他是剑桥大学的生化博士，然后呢，他是密歇根大学的法学博士，然后呢，他曾经在欧洲制裁局工作过，那目前是 Behmert 的这个合伙人，这样也是未来的他们的继承人之一。然后他今天要跟我们讲的是这个欧洲统一专利制。那欧洲已经有统一商标，有统一设计，那现在专利呢也即将有个新的这个统一制度开始。本来希望在明年的2015年的1月就开始，但是现在因为你知道他刚刚讲的一个欧洲，叫做什么欧洲专利的一个协定，所以我们必须要每个国家要签署国际合约，都是有合约之后呢，个别国家要签署同意，变成各国内法，大家一起来遵守。所以他刚刚说呢，那整个欧洲制裁局就放在 Munich 他所来的地方。那你看到红色那一块就是包括在这里面的这些国家，那欧洲是一群国家，就是你看到那一大群国家。
Thank you. That's exactly what I wanted to say. So the European Patent Office then looks at the patent application and examines it for patentability criteria, which are novelty and inventive step. And once it has found that this is a real invention, it will grant a patent, which is shown here in the middle. But then, because each country in Europe still tries to be somehow independent, in order for this granted European patent to become effective in the various member states, so for example in Germany, in France, in Britain, in Italy, in Spain, you then need to take the European patent and prepare translations into the respective official languages of each state, i.e. into French, into English, into Italian, into Spanish and so forth, and then take this translation and file it at the National Patent Office. This means that because you needed to prepare these translations, there is a high cost associated with this. That is the situation until, let's say, 3 years ago.
好，那在这个新制度开始之前，目前的制度是怎样呢？你可以选择在每个国家申请。你也可以选择进入他们叫做 EP， 就是欧洲制裁局申请。那进去欧洲制裁局一段时间之后，再指定国家。但是你要指定到哪个国家，你就要翻译所有专利的全文到每一个国家去。那翻译是很贵，对吧？而且很多奇奇怪怪的文字，我们只有学3种主要的语文，是不是就是法文、英文、德文，这是比较常见。可是你看每个国家都有很多的文字，那就变成很大的负担。对，申请欧洲专利很贵，所以不是那么多人去申请欧洲专利。但是专利又这么样的重要，所以现在呢，这是目前的状况。
In addition, for this European patent to become effective, you needed to pay fees at each of the states. And this was recognized as a big hurdle for many applicants from Asia, from the US, from other European countries, because of the high costs. And so the European Union and the European Patent Office, they made some attempts to somehow make it more tractable and therefore they introduced a single designation fee for all contracting states. And in addition, some of the European member states entered into an agreement, which is the so-called London Agreement, which meant that some of the countries which are member to the London Agreement have waived the necessity to file translations. So in other words, for those countries member to the London Agreement, you no longer need to prepare a 200-page translation of the patent specification, thereby greatly saving on costs.
OK， 所以现在呢，就是说你申请一个统一的规费，然后呢，你只要申请3个主要的国家，就是我刚刚讲的法文、德文跟英文，你就不用翻译到每个国家去，那就是省很多钱。好，所以这是现在他们的一个想法，就根据这个伦敦协议。然后跟这个伦敦同意，他们协议里面签约的国家就可以这样子来做。
So under the London Agreement, all you now need to do is you need to prepare a translation of the claims into English, French and German. And for some of the countries, you still need to prepare a translation of the claims into their respective language. So for example, in Denmark, you need to prepare a translation into Danish. In the Netherlands, you need to prepare a translation into Dutch. Most notably, however, the 3 biggest countries in Europe, namely France, Germany, and the UK, you don't need to prepare a translation anymore because you have already done that when you let the patent go to grant at the European Patent Office.
好，那所以呢，但是有些国家，因为其实每一个国家它不见得听德国、英国、法国话，所以他还是会要求他们的要有他们自己国家的语言。所以他刚刚说，比如说丹麦啦、匈牙利啦，就是比较下面这些国家，你看到这些国家，他就说，那你还是要翻译你的这个权利项。可是刚刚我们是不是说这个专利，我们是不是说有名字 title， 然后有它的摘要，然后有发明的内容，然后接下来有权利项。那但是刚刚说这里要翻到每个语言呢，只有权利项的部分，因为权利是以后诉讼的基础，跟你要权利金的基础，所以这个地方有些国家是要求你要翻他们个别国家的语言。
So that was the situation then until about 2 years ago, and it's important to note that what I've told you so far is all about patent prosecution, which means you deal with the question of how to obtain a European patent. So what was the situation was that until now you would have a central granted European patent which is then split up into various national parts. So just to go back to that one slide, so you have the centrally granted European patent, and then after grant you get a German national part, a French part, a British part, and so forth. This meant now, in the second step, when you wanted to litigate, i.e. if I'm a patentee and I want to go after an infringer in Germany, I can only use the German part to go against that infringer. If I want to litigate with an infringer in the UK, I need to use the British part. And the situation can be summarized, and I'd like to quote J.R. Tolkien, that you have 3 courts for the elven kings under the sky, 7 for the dwarf lords in their walls of stone, 9 for mortal men doomed to die. So in other words, you had courts in every country to use and that you had to rely on in order to go after infringers. And what was the aim, however, is to get one patent that is effective in all member states immediately without any of these validation requirements.
好，那新的统一专利制度就跟以前不一样了，就是说，如果你获得核准，整个欧洲就整个都核准，不要像以前这样一个一个核准。可是有什么不一样呢？以前的时候就说，如果你要在德国撤销它的专利，你到德国去打官司；你要到撤销它的专利，可以到英国打官司。可是现在出现一个问题，既然是一整片一起核准，你可以甚至跑那个小国家去撤销全部的专利，这变成另外一个风险。那但是他刚举的，然后是讲那个指环，那个叫什么？那个电影的中文魔戒，他用魔戒来讲，魔戒那里面他扩了那个作者写的名字说，里面有9个国王要把他们通通杀死，对不对？然后最后剩下这一个，他扩了一个很有学问的一个这个话语，所以各位可以来学习一下。
So the idea behind this now unitary European patent was to get a single patent that you can use immediately for all member states. And here I'm trying to list some of the sort of legislative measures that have been adapted. So you had various European regulations and an agreement, and the idea was to have one patent for all European states with a central litigation. And because France, UK and Germany are the three biggest and most important countries in Europe, don't tell that to the Dutch or the Danish, the central court would be in Paris, London or Munich.
好，那现在就说，那我们刚刚讲到说，诉讼本来你在德国就到德国，法国就到法国。那现在是统一专利制，一定要决定有几个主要的法院就好了，因为这样才不会很麻烦。那所以他们就决定最重要就放在法国、德国跟英国。可是这样像丹麦啊、卢森堡啊这些小国家是不是就很生气？所以事实上，为什么到现在还没有快那么有开始实施，就是还是有这些小问题存在。
Interestingly, two countries opted out of that system, so they don't form part of that, that are Italy and Spain. So for Italy and Spain, you won't get a unitary European patent yet.
OK， 所以但是呢，也有人不同意，因为事实上我们在欧洲就听到了，比如说像波兰人，他就说，谁说你们德国、英国、法国比较懂专利，我们波兰人就不懂专利，为什么你法院一定要设那里呢？那就像现在看到，意大利跟西班牙决定说，我们不要参加你们的制度，你要在我们国家得保护，你还是到我们国家个别来申请吧。
So how do you get the European unitary patent? Basically, you go to the EPO, as with the current EP applications, but after grant, after the EPO has granted your patent, you don't need to take a translation into the individual countries. It will suffice if you only prepare translation of the claims into all three official languages of the European Patent Office, which is French, German and English. And then you only need to prepare a translation of the specification into one other language. So for example, if you have an English language patent, you only then need to prepare one single translation into German. And that will then effectively cover all the member states with the exception of Italy and Spain. Likewise, you also don't need to pay any more fees to each individual country, but you have a single renewal fee for all countries. And finally, when does this all enter into effect? Well, so far it has not yet entered into effect, but I will tell you a little bit later about the future. And there will be a transitional period of 7 years in which a European patent applicant can choose whether or not he wants to be part of that system and wants his patent application to be treated as a unitary patent, or whether it should be a normal European patent application where you have to go into the individual member states.
好，那以前是说你进了欧洲制裁局，然后可是每个国家你指定了一些国家，你还是要一个国家一个国家去缴费。那么现在就决定说不要了，这个每一年缴的费就一起整片欧洲缴一个费用。然后呢，刚刚讲很重要，就是说他刚刚是说3种语言，德文、法文、英文。好，那这是指这个全部你送进去是这样一个语文。可是针对我们讲权利的部分，你只要另外再翻译德文或者是法文，这样就可以了。所以你可能就是，如果你是德文送就全部德文就好，法文送就全部法文就好。如果是英文，就是英文全部送，然后在权利项的部分翻德文或法文，这样就省很多钱。我不是跟大家说过，翻译费打一个字可以3块钱台币，那你整篇专利如果几百页，那可是很不得了的事情。
Now, when you want to litigate such a unitary patent, which courts do you go to? Well, the agreement on the Unitary Patent Court provides for a central court, as I said, in Paris, and then specialized central divisions in London and Munich. The reason being that in London you would typically have all pharmaceutical cases dealt with. In Munich, which is in Germany, you would have all the mechanical engineering cases dealt with because of the German car manufacturing industry, and in Paris you have all the rest. In addition, you would then also have local and regional courts in the various countries, and you would have a court of the second instance in Luxembourg, which is a small country. You know, in Europe we are this sort of bunch of nations, and every nation wants to have their bite into the big cake. And so Also Luxembourg wanted to have something, and so they got the appeal court. What are these different courts responsible for? Well, the central court is responsible for revocation and nullity actions. If, for those of you who don't know what a revocation action is, if you are a defendant in a patent suit, you want to kill the patent basically, because this is the instrument that you are being threatened with. And you do that by way of a revocation action. So the central court in Paris, London or Munich will deal with these revocation actions. And in addition, it will deal with infringement actions if the infringer is not located in the European Union. Additionally, you have the local courts in various countries, and these are responsible for infringement actions where the infringer has its place of business or where the act of infringement takes place.
好，那其实呢，如果今天专利发生纠纷，你还是可以在每个国家自己的地方法院打，但是呢，你也可以把它集中，它有几个被专利比较专门的法院，所以他就说伦敦有一个，慕尼黑有一个，巴黎有一个。那因为德国汽车工业很强，所以机械方面的案件就到慕尼黑去打。那因为不知道为什么，所有的医药的案件大家喜欢去伦敦打。按照他们统计起来，所以伦敦的部分就负责这个部分。那巴黎因为在欧陆的中间，那它又比较不惹其他欧陆国家讨厌，所以所有的案件虽然你可以在慕尼黑打，你可以在伦敦打，但是你也可以统统拿到巴黎去打。那但是呢，你不能够只有这三个大国，其他小国会生气，所以要把上诉法院，就是我们讲的二级法院放在卢森堡。然后另外他说呢，如果你要撤销这个 revocation， 就是说你被人家告你要怎么办？说他专利无效，不然就撤销他专利。所以这就是这两个部分，你可以去找这些中心法院，你可以在地方法院，你也可以找中心法院。中心法院比较专门，比较不会出错，所以中心法院就是可以来处理专利无效或者要撤销别人专利的这些案件。
So what will the court proceedings look like? Typically, if you look at the first instance, the proceedings will be over within a year, 1.5 years, and at the end of those 1.5 years, you will have first instance decisions. The proceedings will mainly be in writing, in the sense that you will have an oral hearing at the end, but unlike in the US, where you would have a hearing possibly over several days or weeks, with lots of witnesses and depositions, etc., in this unitary patent court, you will typically have a single day hearing, and that may last for as short as only 3 hours. So the main proceedings are in writing. You have what is called a so-called bifurcated system, which means that infringement actions are being dealt with in one type of proceedings, and revocation actions are dealt with in a second type of proceedings. What are the advantages and disadvantages? Well, if you are a patentee and you want to not go against an infringer only in one country but in several countries, it is much easier to do that in these centralized proceedings, because you can then obtain an injunction within all member states by one single decision. The disadvantage for you as a patentee is, however, that of course the defendant or the infringer will try to defend himself and he will try to kill the patent, and the single ruling in the revocation action will effectively kill your patent within all member states. And the same advantages and disadvantages can be also said for the defendant. He can get an injunction against him. In other words, he can be forbidden to enter the European market in all member states by a single ruling, but he also has the chances to kill the patent in all these member states.
好，那现在就说呢，那你开始打官司的时候是什么样的情况呢？一个可能就是说，好，那你可能在地方法院打，对不对？每个国家地方法院，因为有效就是这个地方法院。可是你如果去刚刚那三个中心法院打，你一旦得到对你有利的判决，就是对整个欧盟有利。可是有的时候你又想要找到某些法院，因为比如说伦敦的法院，伦敦的英国的案件一向都比较偏非权利人，德国的法院比较偏向权利人，每个国家有他对专利不同的意见看法，那你就会挑不同的法院，所以它是有那种双系统，就是你在这个法院被告，你跑到另外一个法院，对你比较有利的去撤销它专利无效，所以会有这样的情况出来。
Okay, so it's very important for clients of ours to know about costs, and so in this slide I will talk a little bit about cost, in the sense that What are the advantages? How can you save money? So there may possibly advantages on the translation cost because you will only have to prepare a single translation. Having said that, however, bear in mind what I told you earlier, there is already the London Agreement in place, which already put away with the necessity to prepare translation for many countries. The annuities, the maintenance fees, which you had to pay in various member states, they all have been put away, and you have a single annuity fee to be paid. If you are, for example, a big pharma company, and you are used to multi-jurisdictional litigations, in other words, you would typically litigate in 5 countries, the costs of these unitary patent proceedings will be a lot cheaper. If you're a small or medium-sized enterprise and you typically only litigate in Germany, then the costs may actually be higher because the fees may actually be a lot higher. If you are a patent applicant who typically would file only national applications, then also your filing fees may be considerably higher than if you were to use only national applications.
好，那其实现在企业最担心一件事就是到底这些钱怎么算？以前是你申请EP是一个钱，然后进入每个国家，看你要选多少国家，再讲这个国家的会费。你可以申请很多，你可以申请很少。如果你申请很多的，现在这个新系统你就比较划算，因为你缴一个中心的规费，每个国家把他们的这个每个国家个别的费用维持费降低 ，polling 变成一个系统。那如果你要申请很多国家的，现在用这个系统就比较方便。可是有些公司是只打算申请重要国家，因为小国家也不见得有能力抄袭你的专利。那在这种情况下，费用可能会变得比较高，因为它现在这个费用是对整个欧盟，而不是对单独的国家，所以有利有弊。那到底费用多少？现在大家还在讨论当中。
So, if you were a client of mine, what would I recommend you to do with this unitary European patent system? Well, you should not go for just national applications. Instead, what you should be doing and what you should be considering is you should always file via the European Patent Office, and you will have the chance to opt into the system and say, my European patent application should be a unitary European patent. If you have limitless amount of money, which at the moment seems to be the case with some of our mainland Chinese clients, we also recommend them to go to national applications. So in addition to filing a European patent application, we will also encourage them to file national applications, because that allows them to take advantage of the unitary patent system and at the same time be sure that you also still have a national patent if something goes wrong with your unitary patent.
好，那现在就说，你知道说我们可以申请个别国家，我们可以申请 PCT， 然后还可以申请 EP， 那你也可以申请欧洲个别的国家。那对企业怎么办？他说，如果对中国的企业，他通常的建议都是，你比如说你要进德国，你德国先申请，但是你同时还是申请这个统一专利制。为什么？它有一个宽限期间，可能有一天，比如说华为现在忽然变很大，你想要整个欧洲的权益的时候，你还有机会。所以他会建议说，你还是要两边同时申请。那中间有一个叫做过渡期，你可以选择你要回去新的欧洲统一制，或者是你要回到旧的欧洲制，或者是你只要单独的国家你另外再申请。这是很多企业现在的做法。
And then this is the penultimate slide. So this is just to give you a little timeline of what has happened so far. Has this all come into force yet? No. At the end of 2012, we had all the regulations and the agreement being agreed upon by the European Parliament in Strasbourg. In February 2013, all the member states signed the treaty, but being Europe and being a bunch of nations, these different regulations still need to be put into national law. And that is a process called ratification, which is shown here. And according to this treaty, ratification is necessary in 13 member states, of which there must be the UK, France and Germany as the 3 biggest. Now, as of today or yesterday, the treaty has been ratified in 5 countries, as important as Austria, Belgium, Denmark and Sweden, and then of the 3 big ones, there's only France who has ratified it. When will it act go into place or into force? Well, we don't know. In Germany, at the moment, there's some sort of political debate about whether it should be ratified at all. In the UK, we will have a general election next year, and no one knows what comes out of that. And I would say, if the European Unitary Patent comes, the earliest it will come will be in 2016, but it may at the same time also not come at all, depending on how the political process, especially in the UK and Germany, will go over the next year or so.
那本来呢，这个在年初的时候，大家一直都说明年欧洲统一专利制就要上路了。可是现在大家看到呢，你要知道说国际的合约是怎样，大家一起来讨论，讨论完我们说要做这件事了，我们要回去个别国家的国会还要同意，然后再来签署。所以在这个合约里面，他们规定要是3个国家，3个大国，还有10个小国，不能说小其他的国家。所以他现在你看到他这边看到呢，你看到的就是3个大国也只有法国签了。那另外有5个已经签，就是奥地利、比利时、丹麦跟瑞典，所以还有一段路，你至少还要在5个国家签，还有2个大国签完。那每个国家有自己的选举期限，就好像你的服贸是吵了很久，他都签了没，所以不是那么容易一件事。所以他现在才搞不好2016年都还不会开始。
And I would like to finish, so this is my last slide, with a picture of not the European Patent Office, but a picture of our firm's office in Munich. For those of you who happen to come to Munich and would like to visit us, please feel free to do so. Also, if you have questions about this lecture and would like to know something, I'm here to answer questions, but you can also send me an email. And this is our office at day, and this is our office at night, and that is when we are working at your patent applications, and this is my office here. So thank you very much.
老师呢，就是他们的事务所，他们事务所在那个慕尼黑总车站走路会到的地方，非常漂亮的大 building。那他说大家欢迎有问题都可以问他，同学有没有什么问题？问题加分，我可以帮你翻译，你可以问中文，也可以问英文，你也可以问他说，他是怎么样变这个专利律师？你也可以问他专利律师生活好不好过，然后你也可以问很多其他的学习上的问题。有没有什么问题？
至少有一个同学发声吧，
或是老师们要不要问问题 ？OK， 同学先给同学好了。
可是他生化是哪一方面的？
He would like to ask you major in biochemistry and what is your research about?
My research, when I did my PhD and my diploma degree, I did work on protein folding. So I was working on structural biology.
就是蛋白质 RNA 的结构，蛋白质怎么样做成它的那个一体结构
It means molecular biology.
I used molecular biology, but basically, if you are I was studying the structures of proteins. So the way how a protein folds into three-dimensional structure.
就好像你的胶原蛋白，头发的是3股，对不对？然后有一些是卷成螺旋形，有些是什么形？那为什么它会这么卷？里面的键结，那就是化学。好吧？他们什么
？OK。要聊2个问题。第一个问题是那个专利师在国外专利师，有没有像台湾是分专打诉讼跟专打写那个专利文章的？
Okay, he would like to ask about the patent attorney system because in Taiwan we have the patent agent, they draft the patent, they have the patent attorney, they can go to the court. But what is the patent attorney system and how they function in Germany?
Okay, so a German patent attorney is like myself, first of all a scientist or an engineer, and I've done some additional legal training, which means I have gone into law school in evening classes after my science degree. Once you have done that, you need to take an exam, and then you are a qualified German European patent attorney who is allowed to represent at the patent office, the German and the European patent office, and you can also appear in court, but you need to take a lawyer with you. So there will be in court, there will be 2 people, a lawyer and a patent attorney.
那所以他们呢，他其实跟我一样，就是先念了一个 PhD 在科学，然后在晚上再去念了一个法律，但是你还是要通过考试。那么考试完以后呢，专利律师出庭还是需要一个法律的律师，除非你另外有考过法律的律师，基本上是很类似的。但是台湾呢，就是我们是3审才要律师，所以你1审、2审是专家也 OK。但是在德国呢，每一审也就是律师负责法律方面的工作，专利律师可以解释法规、科学，但是他还是一定要律师在，所以他们的诉讼费用比较高。
第二个就是台湾那个专利师好像大部分都是不是非本科系的，比如说机械的，就我委托专利师的话，他都是可能是读法律的，根本就不知道我们在做什么。像德国会发生这种事情吗
？He mentioned in Taiwan, in old days, we don't have a patent attorney exam, so who represented us, they would be the accountant or lawyer, but I know nothing about it. And for those patent agents, they dropped, but I don't have a certificate. But now, I think 5 years recently, we have a patent agent system now, so you may call it as patent attorney, but the patent agent certificate, they don't necessarily have the legal training. So you would like to know what is similar situation happen in Europe that people don't know science or people don't know law, they will represent your case in Germany?
No, it's always been in Germany ever since the patent attorney profession was founded that you would have a technical person doing additional legal training. So always patent attorneys in Germany and in the countries like Britain and France, they would be technical people who have done additional legal training. And basically, as a patent attorney, it's very important that you understand the technical concepts and you act as a translator. You speak with the scientist, you translate from a technical context into a legal context. So you must understand the technical side and the legal side.
所以在德国不会有这样的事情，因为你要做专利律师，你一定要有修法律学分的，而且要考试通过。所以你要练习的就是，你要把科学的语言变得精简，而且你要能够用法律的语言去说明它。所以基本上在欧洲，其实包括连英国或者是在日本啊，或者是在其他比较先进国家都不会有这样的状况。那台湾也在进步当中，所以现在也没有这种情况了。Any questions?
专利是有考一张就全球适用吗？还是每个国家一张？
I can answer this question. He asked for the patent agent certificate, is it like a uniform patent system? You pass one for all, or you have to take one exam each country?
Okay, so I have 2 qualifications. I'm a German patent attorney, which allows me to practice at the German patent office and in German courts. And I'm a European patent attorney, which allows me to represent at the European Patent Office. I'm not allowed to practice in UK courts, I'm not allowed to practice in front of the UK Patent Office. I can appear there, but I'm not allowed to represent clients there.
大家知道英国没有加入欧盟的，欧元区也没有英国，所以呢，但是他考了2张，一张是德国自己的，一张是欧盟，所以在欧盟没有问题，在德国没有问题。但是在英国呢，1审就一定是英国的律师，英国还有大律师跟小律师，就是刚刚这位同学讲的，是写文章的跟出庭的。那但是在上诉法院的时候，2审的时候，他们就可以在英国出庭。但是在台湾，你就考台湾，只能在台湾，你们通通可以考中国，对不对？所以我是不是有给大家这个考试的用书？所以呢，我们等一下要告诉你怎么准备。有问题吗？好，如果有问题，等一下可以继续问。So we thank you very much for Professor.